Prospective house buyer Anthony Edwards and licensed realtor Jerry Isom entered a property at 1093 on November 17 Maradu Drive in Cincinnati, Ohio's West Price Hill neighborhood using a lockbox key that Isom had been given permission to use. Thomas Brannigan, a retired Cincinnati police officer and neighbor across the street, reported to 911 that he had seen two black guys push the front door open. What was reported as a breaking and entering prompted officers to arrive. The officer's body camera recorded the subsequent exchange.
32 forms the other side around the building. Now you're correcting the exit.
8120 responding. Nav out. We'll put it out. Copy. 3235 repeat.
Where's the...
Copy.
Where's Knox at?
Copy.
Movement in there.
Address 1093 Murado.
Pete, they're right up there by you. Pete, they're right up by your window. Want to order them to come out?
Hey guys, come on out. Come out front.
Knox! Hands up!
My hands up, what y'all doing?
Tell your friend to come out too. Hands up.
Come on out, man. We got a fucking appointment to see this out.
Well, people saw you forcing your way in, that's why we're here.
Oh man, I don't know. They just white people calling the goddamn police doing that bullshit.
Okay.
And I ain't even gonna buy the
Call
house.
me in a good neighbor. You see somebody going into a house.
I ain't gonna buy the house. I ain't even gonna buy it.
How'd you just get in?
He a realtor.
Turn around. Till we can confirm. Turn around. Until we can confirm. Did you use a key? Where's the key at? Where at?
Don't worry.
Have a seat.
We was white, they wouldn't have did this.
So what are you talking about, man? That's some ignorant shit you're talking about.
You got some type of realtor ID on you?
I don't give a
Where's
damn
that?
if you're white or black. We're doing our job
I
here.
didn't say you what.
In your pocket or your car?
But that's bullshit though.
Okay, you want...
Two black guys.
Turn around.
Two black guys. I want to go to jail.
Where's the...
Why were you going to jail?
Where's that?
Break in, then you're not going to jail.
Put me
Huh?
in handcuffs if I was white.
Call me in the
What?
I couldn't hear you.
Where's your realtor ID?
That's it. You got anything sharp on you?
No, you can take them to open the jacket up. I got ID in my pocket. Y'all didn't ask for the ID.
Where's your... Do you have, like, ID on you? Which pocket, sir? You've got lots of pockets. Turn around.
Stretch your legs.
Yeah, dude.
It's amazing.
It is amazing. Isn't it two white guys? Yeah, we went through all
Yeah, we would.
Well, we
I
don't
guess because you ride along, you know what we do, huh? You know how we do our job, don't you?
I mean,
It's incredible. Step down here.
It's every day. This is the everyday deal.
The first thing to comprehend in this situation is what these cops received and did not receive from Brannigan's 911 call. The Supreme Court ruled in Navarrete v. California, 2014, that a 911 tip can provide reasonable suspicion to support an investigative stop, because there is little opportunity for intentional or conscious deception. Statements made shortly after seeing an occurrence are particularly reliable. A judge would probably find Brannigan's tip credible enough to support stopping and briefly detaining Esseman Edwards in order to ascertain what transpired, because he is a retired police officer who is familiar with the area. The legal authority ends there. Officers are no longer looking into a crime when Esseman identifies himself as the realtor and says they entered through the lockbox. Instead, they are looking into a credibility issue. Officers are prohibited by the Constitution from assuming guilt and requesting evidence of innocence. According to the Fourth Amendment, officers must take into account all that is in front of them, not simply the initial account they...
Now you're searching like you got drugs and dope.
Knox, I didn't search...
You got an idea on you somewhere?
pat between his crotch and stuff for weapons, but he's got an ID and he's got realty cards on. So who'd you arrange this with?
Are you the only two in there?
They're saying let's go up. We're talking to it.
And you got into the key box?
Yeah.
Play the race card. Okay, that stuff doesn't fly.
We got called and told that you guys forced entry, which is why.
I don't care.
So just stop.
I don't care. I mean, stop. Do you have an idea?
Yeah. And he's got Realtor cards on.
Take a deep breath and relax.
Good. Not that.
That's up to you. We had nothing to do with what you buy and what you don't buy.
I go right around the corner.
So you're surprised there are a lot of houses that are evident. When someone sees what they believe is that, we have to look into it. That's what we have to do. We have to look into it. We don't know who you are.
No, I ain't talking about that. I'm talking about what the cause of the complaint. So
That's not what was important.
Do you have the key to the lockbox on you? Is it in there?
Why we approach things a certain way. Your race has nothing to do with it.
Hey, which pocket is it?
Hold on.
Now, Officer Valentino did not perform a Terry frisk. A Terry frisk is limited to the exterior of a person's clothing for the specific purpose of detecting weapons. It was established in Terry v. Ohio, decided in 1968, where the Supreme Court held that an officer may perform a limited pat-down of a suspect's outer clothing if the officer can articulate reasonable suspicion that the person is armed and dangerous. The Supreme Court made it clear. The officer must be able to describe the specific risk or danger to the officer or others, as well as why officer safety was a concern. Officer Knox had already informed Valentino that Isom had ID and real estate cards on him and that he had already searched for weapons. The foundation for any further search had vanished by that time. It is not a pat-down to reach inside Isom's pockets and collect objects. It's a comprehensive search, which requires probable cause rather than reasonable suspicion. These cops had reasonable suspicion to stop because of the 911 call. They lacked probable reason to conduct a search. These are two different things, and this is the point at which that distinction was made.
But I didn't break the fall. Well, not.
What about the little... Shouldn't it be like in a little...
parking scene.
Okay, well, you can't find it.
Back up, yeah.
Turn around, sir.
If you would
Again, everything's important today, my friend.
Bro, don't even worry about it. You ain't have anything about it out. You alright? Yeah, another point to it. We out here. I'll call you. You don't want to go up here and one up the street.
Sorry about that, sir. We can only go by, just report it to us, okay?
I had it in my
Yeah, I couldn't find it, so.
Put it back on? No, not yet.
I still left it inside. Yeah.
Although Iceman Edwards' release is the proper result, the manner in which it takes place exposes a second significant shortcoming. From the beginning to the end, the inquiry was careless. The situation was never secured by the officers. They treated the two individuals he accused like suspects who needed to establish their innocence while allowing the complainant, the man whose story started everything, to move freely. Securing all participants and gathering information evenly before making conclusions is a fundamental investigation principle. That is not what these police did. Brannigan's version was the first to be accepted, and everything else was sifted through it. They just left after discovering that a key had been used and that there had been no forced entry. There was no on-camera interview with Brannigan, no report pointing out that his story was untrue, and no responsibility at all for a fictitious 911 call that put two innocent individuals in danger. Officers Pete, Knox, and Valentino receive an F. Before either man posed a threat, Valentino pulled out a gun, and the 1989 Graham v. Connor ruling from the Supreme Court was unambiguous. The gravity of the crime, whether the suspect poses an imminent threat to the safety of the officers or others, and whether the defendant is actively fighting arrest or trying to flee arrest must all be taken into consideration when evaluating the use of force. At that point, none of those reasons supported drawing a weapon. After Knox informed Valentino that no firearms were discovered, Valentino proceeded with an unauthorized pocket search. Long after a tenable innocent explanation had been presented, Knox approved of a strategy that assumed guilt and ordered the detention to continue. Pete was there the entire time and didn't object. Collectively, these policemen abandoned the impartiality required by law enforcement, not because they were malevolent, but rather because they considered Esam's credentials as a fraud that needed to be proven and accepted Brannigan's word as gospel. Investigations don't operate that way. The Fourth Amendment does not operate in that manner. Esam and Edwards filed a federal complaint on July 15, 2019, claiming improper officer training and Fourth Amendment breaches. About 3 days later, the city of Cincinnati reached a settlement in which it paid Esam and Edwards a total of $151,000, apologized formally, and promised to provide implicit bias training to all city workers. A city is aware of what transpired when it settles in 3 days. Thomas Brannigan, a retired police officer, receives an F. He is a qualified law enforcement officer who reported a forced entry by 2 black individuals to 911 after witnessing 2 men enter a residence using a key through a lockbox. Either his perception or his description of it was incorrect. In any case, a man with police training who identifies himself to responding cops as such has more credibility than a tip from a random citizen. Training and proximity to an event increase the weight assigned to a tip, according to the Supreme Court's findings in Navarrete v. California. The damage Brannigan's bogus story created was exacerbated by his status. His call was never the subject of a formal investigation. He ought to have been. Jerry Isom receives an A+. Throughout an embarrassing, needless, and illegal scenario, he remained composed, cooperative, identified himself right away, and gave a clear explanation for their presence. He refrained from escalating. Officers had no motive to escalate the situation beyond what they had already done because of him. And he didn't just move on after it was ended. He launched a lawsuit, demanded responsibility, and assisted in forcing the implementation of systemic implicit bias training in a large American city. That is the appearance of civic courage. Anthony Edwards receives an A-. Edwards expressed his annoyance loudly, and he had good reason to do so. His statements were all true. However, there is actual risk associated with noisy protest during a detention, regardless of how legal the protest is, and that risk is never shared equitably. Isom's play was the more astute one at the time. Talk as little as you can, wait for the matter to be resolved, and then explore all available legal options. Edwards did seek those solutions. For that, he deserves a great deal of praise. The only reason there is a negative is that the loudest voice on the street is not always protected by the law, even when that voice is entirely correct. If you would like us to talk about any interactions or legal matters, please let us know in the comments section below.